Welcome to this presentation on the merger of the National Practitioner Data Bank and the Healthcare Integrity and Protection Data Bank. We're putting this presentation together for you, our listeners, so that we can ensure that you have all the details that you need required to knowing about the merger of the two data banks. I'm Erna Hughes, Acting Director of the Division of Practitioner Data Banks. Joining me are Molly Wyrick and Laura Burns. My colleagues and I are here to offer you support. We welcome every opportunity to talk with you individually and to answer any questions that you may have. Today we'll share a bit with you about the highlights of the merger, which include the statutory and regulatory changes related to the merger, day-to-day operations changes, and any additional resources that you may need following this presentation. Depending on when you're watching this video, the merger may have already happened. The information, however, remains the same and current.
So let's get right to it. Why are the data banks merging? The short answer is that the Affordable Care Act, which was signed into law on March 23, 2010, required us to merge the NPDB and the HIPDB. However, while the Affordable Care Act authorized the merger of the data banks, it was really set in motion many years earlier with the passage of Section 1921 of the Social Security Act. And we know that the Affordable Care part is one part of the Affordable Care Act.
That's right, Molly. We're actually really proud of the fact that the whole title of the Act is the Patient Protection and Affordable Care Act. At the Data Bank, we're really proud of our opportunity to realize the portion of the Act that speaks to patient protection.
So without going into too much detail, Section 1921 created report duplication. Some actions that were already being reported under HIPDB were now required to be reported to NPDB under 1921. The Affordable Care Act is really a vehicle to make this merger happen and eliminate the duplication in the data banks.
So the final rule was published in the Federal Register on April 5, 2013. Rule or regulation becomes effective on May 6th.
And as you said, the overarching goal of the merger was to eliminate this duplication in the data banks. There are 3 statutes that govern the HIPDB and the NPDB. Those statutes remain in effect. They're not going away. The Affordable Care Act simply consolidates the 3 under one system.
As we're talking about the highlights today, there are really 2 major takeaways. So if you remember nothing else from today's presentation, of course we want you to remember all of it, but if there are only 2 things, here they are. The merger creates one data bank and one set of regulations. This merger actually does something pretty significant in the federal government. We are eliminating regulatory burden on all of our users by eliminating a federal regulation. Now, how often does that happen in the federal government? So we're very excited to be part of this really terrific opportunity for you, our users.
And this definitely is a highlight, what Molly's just said. So let's look at some of these other merger highlights. I'm sure at this point you're thinking, what does this mean for me? Well, how does this merger affect my reporting and querying requirements? The good news is that this is basically a technical change and has very little effect on how you report and query. Reports that were stored in the HIPDB and the NPD prior to the merger are now all available in the NPDB. And why is this? Think back to your takeaways, because there's one data bank.
Another key point is that there will be no need to re-register with the data bank to implement the merger. Now, some of you may remember that when Section 1921 went into effect, you were required to re-register with the data bank. We heard a lot of grumbling about that. But with this merger, the registration flagging systems will be automatically realigned. The work has already been completed, and because of that, your reporting experience will remain the same. Now, of course, as you know, as a data bank user, you are required to re-register every 2 years. That part won't change. Also, we want to emphasize that the authority for certain reportable actions has changed. We'll get into those details in a minute, but no user action is required. The bottom line here is that if you had to report before, you will still be required to report. There are no changes to how or what you report.
We have some more good news for our users. If you, prior to the merger, queried both the HIPDB and the NPDB, you would have been charged twice, one for each of those queries. Now that you're only querying one, the NPDB, you'll still get the same reports back on that one query, but for that one price. So this is some cost savings.
Many of you have asked if the query fee is changing because of the merger. There will not be a new query fee in effect when the merger goes into effect. The data bank, however, is now engaged in a study to look at various options related to the fee. Any future plans involving changes in fee will be posted in the Federal Register.
And finally, on this slide, we have some information about our new website address. We encourage you to use the new address, change your bookmarks, change your favorites, but if you do happen to type in the old address, you'll be automatically redirected.
Great, thanks. As we said, there have been some changes to the statutory authorities. Now, I know some of you get really excited about statutory and legislative changes, so this is for you. For those of you who don't get quite so excited about this, if you want to check your email, take a minute now to do it. So let's get into it. Let's review the statutory changes just for a moment here. Again, these don't affect what you report or how you report. Although there are 3 authorities, each report will be stored in only one place, the NPDB. Whether an action is reported under Title IV, Section 1921, or Section 1128E will depend on how you were registered and what you identify as your primary function. So an example of that would be a hospital that is also a government agency. If the primary function is a hospital, the reports will be flagged according to the primary function of a hospital, not a government agency. So that's how that will play out. Now, Title IV, the statute that created the NPDB, was untouched by the Affordable Care Act. That leaves Section 1921 and Section 1128E of the Social Security Act.
So Section 1921 was altered by the Affordable Care Act. Some actions that had previously been reported under 1128E are now reported under 1921. An example of this consolidation are state licensing and certification actions. Prior to the merger, actions against practitioners and entities were in one data bank. Actions against suppliers and providers were in another. So now they're all together consolidated. Another example would be healthcare-related criminal convictions that are state-based and civil judgments. Those are all reported under 1921 now.
So Section 1128E was split, with the components we just talked about going into Section 1921. Because 1128E created the HIPDB, and the HIPDB data are being incorporated into the NPDB, the 1128E authority will continue to exist through the NPDB. For the most part, federal and health plan actions stay under the 1128E authority. Now, there may be some questions that come up around this. Just recently, I gave some information to some health plans, and they're one of the groups of entities that will live under 2 different authorities, Title IV and Section 1128E. So we know that some of these questions are still a little quirky and they may come up. We will absolutely work with individual users at any time to help work through whatever the issues are on a case-by-case basis.
So again, Molly and Laura are 2 members of the data bank team who are very customer-oriented. We really encourage you to call with those individual questions, as we're happy to respond to them.
So some additional questions have been raised around the effective dates for reporting and querying. Now, as we've said, the effective date of the new regulation is May 6th. Each underlying statute has its own effective date, and those do not change. So for instance, if something is reportable under Section 1128E, that goes way back to 1996. So again, the underlying statute effective dates don't change. The merger effective date is May 6th.
In addition to these statutory changes, the regulations were modified as well. The NPDB and HIPDB had 2 separate regulations prior to the merger, and the Affordable Care Act required that we merge those 2 together, which you can imagine was a big task. In some places, we could simply move language from one regulation to the other. In others, the Affordable Care Act required that we added new language. An example of a regulatory modification would be the new regulations actually reflect our current practice of requiring reporters of medical malpractice payments and adverse clinical privileging actions to send the report directly to the NPDB and then also forward a copy of that report to the appropriate state licensing board. This is all automated through our report forwarding function. This has been the practice since we moved from paper-based reporting to electronic-based reporting, but the regulations needed to be brought up to date. So for most users, this is not a change, but for some of you still doing paper-based reporting, it is a change.
Also, the new regulation makes the reporting time frame consistent. You're going to hear a theme that we are trying to make much of what we do in the data banks more consistent. We think that's a good thing. All reports are to be submitted within 30 days of the date of action. The pre-merger regulations allowed 3 different ways to count the 30-day time frame. Well, we've decided that we're going to count to 30 in just one way with the new regulations. Also, the immunity provisions for all reporters are now consistent. Title IV and Section 1128E had the provision that essentially provides reporters immunity from liability in a civil action filed by the subject of a report, as long as the information in the report was truthful. Well, now that same provision is extended to reporters under Section 1921.
Definitions were also modified. In some cases, the definitions were inconsistent with one another between the 2 regulations. An example would be the definition of state. We went ahead and used the definition that was in the NPDB because it's more expansive to include more territories. So for your purposes, the definition of state includes DC, Guam, Puerto Rico, the Virgin Islands, Northern Mariana Islands, and American Samoa. And another example, maybe more significant, is the definition of practitioner. Prior to the merger, we had in the NPDB, you would see physicians, dentists, and other healthcare practitioners. Now, practitioner refers to all regulated healthcare practitioners.
Now, you may still see references to physicians and dentists in the new regulations, and that's intentional. There are still places, for instance, in reference to clinical privilege actions, where we have to call out physicians and dentists because there is reportability that is specific to physicians and dentists. So in those cases where we do have to differentiate, we do. In all other cases, as Laura has said, we're using the term practitioner. There's another definition that we really want to draw your attention to, and that has to do with the definition of negative action or finding. Now, Section 6403 required the Secretary, and as a result of requiring the Secretary through us at the data banks, to conform the inconsistent regulations, and to the extent possible assure that the maximum coordination of the statutes took place. That's really why we're having to adjust some of the definitions. So negative action or finding is one that many of you take a look at. It's one that many of us on the compliance side and policy side refer you to on a regular basis. So we've maintained the National Practitioner Data Bank reference, the NPDB reference, to reportability of administrative fines or citations and corrective action plans. Specifically, that these are reportable if related to the delivery of health care or taken in conjunction with another reportable action. The definitions in the NPDB and HIPDB were not consistent for this. So again, I want to reiterate that we are keeping the definition that was in the NPDB under Section 1921 for negative actions or findings.
So Molly emphasized the theme of consistency. I'm going to emphasize the theme of customer service and just amplify the point that it's important to look in your definitions section, and if you have a question, feel free to call us. That's why we're here.
So most of what we've been talking about up to this point has had something to do with reporting. We'll focus a little bit on querying now as we look at the day-to-day operational considerations. Your reporting requirements haven't changed, but you may see some new reports as a result of your querying. Some queryers may see an increase in reports because they have access to things that were previously housed in HIPDB and are now under 1921. This change will predominantly affect hospitals.
A couple of other operational considerations have to do with query enrollments and credits. The HIPDB continuous query enrollments will convert to NPDB enrollments. Also, the HIPDB credits will be converted to NPDB credits. Now, you might not be familiar with this term, credits. If you don't already know what these credits are, what that really means is that you don't have to worry about that at this point. There were some unusual circumstances that required us to set up credits. So if you don't know about it, you don't have to worry about it. Now, if you submit government administrative actions, new codes have been posted on our website. The operational codes have been changed to ensure that the right entities are getting the right access to the right information through the right reports. If you are a QRXS user or an ITP user, you might want to take a look at those codes now You will be required to do some adjusting to your systems to be able to assure that when May 6th rolls around, you're ready to go with the new codes.
Great. So we were happy to share with you some highlights, but we suspect that you're going to have additional questions, and we're ready for those additional questions. We're going to have a series of webinars where you get to phone in and ask details related to your situation. We're posting for you the days and times of those webinars, and we strongly encourage you to take part. If you're unable to make those times, again, feel free to give us a call to take advantage of us as resources.
And finally, we are providing you with a list of resources. We are continuing to update these resources. So if you go to our website today, which is the day we're taping this, there are some resources available. Between now and May 6th, and then certainly after May 6th, we'll be updating and revising the resources to make them as responsive to what we understand your needs to be as we possibly can. So as we have discussed, we're hosting a number of these Q&A sessions. We'll keep an updated list of the questions and responses on the website. So please do use that resource if you have a question. Chances are somebody else has already asked the question and we've provided a response. We'll say it again. If you cannot find the answer to your question, contact us. We've given you lots of contact information. We're certainly available to be reached.
So in addition to these electronic resources found online, just to reiterate what Molly said, we have the Customer Service Center available to you for all your technical assistance needs. And not listed on this slide, but a resource that we think will be of future interest to you is our guidebook. We are updating our guidebook. It should come out in fall 2013, so look out for that. Until that happens, use the old guidance online. There's still some really good information there. The new regulations supersede that, so if there are any questions, again, don't hesitate to call.
Thank you for joining us today for this presentation of what you need to know about the databank merger. And one more time, the two takeaways for this presentation: there will be one databank and one set of regulations. So, thank you.